What's up, everyone? This is your host, Ghost, coming to you live with another wonderful video. How is everyone doing today? Doing well myself. We got a few things we're going to talk about. We're going to talk about the drama going on in Georgia. 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 There's two cases in Georgia that has some interesting stuff going on. One is, less interesting than most. It's the Trump election interference case. As many have know, there was an appeal done after the judge ruled that what was his name? The special prosecutor had to be dismissed, but Fannie Willis could stay, or vice versa. And that's what special prosecutor recused himself or whatever, and then Fannie Willis stayed. Well, then there was an appeal saying like, "Hey, Fannie Willis should also go too," and now there's a interlocutory appeal on that. We're gonna go check that out for a quick second, and then the Young Thug trial. It's at a surprising upset where when the lead defense attorney was taken into custody due to an apparent improper secret meeting. I'm calling it a conspiracy that led to a witness doing an about face and not testifying, it looks like. He was sent to jail for contempt. The Georgia Court of Appeals, said, this is it's not right. Or sorry, not the appeals. The Georgia Supreme Court did so. So we'll check all this out. Fannie Willis proving she's a corrupt DA time and time again. It's very interesting. We'll check out the Court of Appeals first and what she tried to do with that one, or the appeal in the Trump case. Then we'll go Young Thug. And we got a monster in Ohio. A woman decided to stab a 3-year-old to death in Ohio, and she showed very little to no remorse, and actually seemed to have enjoying herself. We'll watch the video of her reaction. We'll listen to the father. We'll check out a video of the father listening to as well, and so go from there. And then finally, in Washington, a transgender athlete won a state high school track championship, but apparently didn't get the support he thought he was going to get, which is great. If Washington's doing it, and it's just as good as if California and New York was doing it. It's showing more and more people are waking up to the absurdity of all this. And then we might have something else, but we'll see how much time I got at the end. Little housekeeping. Follow me on X at officialwghost. That's the best way to find out when I go live. You can also watch me live as well. You can also follow me on Rumble, rumble.com/withghost. YouTube is at withghost. Twitch.tv/officialwithghost. And then my gaming channel for Rumble is Gaming with Ghost. On YouTube, it's at Official Gaming with Ghost. So those are your various options to watch me and enjoy my beauty. No, not really. But yeah, so let's get to it. So, shoot. There we go, presentation. All right, the appeals court has halted Trump's Georgia case during appeal of order allowing Willis to stay on the case. You guys don't remember, there was some improper shit going on with Fannie Willis and the special prosecutor. Special prosecutor ended up resigning or leaving Fannie Willis on the case because the judge said, well, something, this was an improper action. So either one of you needs to go. Trump's attorneys or the attorneys on the case say, well, I mean, if you view this as improper, both should go, not just one of them. as both were involved. So they sent an appeal to the court, which caused an interlocutory appeal, which means basically the case does not go forward until this appeal is heard. So let's go check this out. An appeals court has halted the Georgia's election interference case against former President Donald Trump and others while it reviews the lower court's judge ruling allowing Fulton County District Attorney Fannie Willis to remain on the case. The Georgia Court of Appeals order on Wednesday prevented Fulton County Superior Court Judge Scott McPhee from moving forward with pretrial motions as he had planned while the appeal is pending. While it's already unlikely the case would go to trial before the November general election, when Trump is expected to be the Republican nominee for president, this makes that even more certain. Was this written? Okay, so the appeals court on Monday docketed the appeal filed by Trump and 8 others and said that if oral arguments is requested and granted, it is tentatively scheduled for October 4th. The court will then have a mid-March will have until mid-March to rule, and losing sides will be able to appeal to the Georgia Supreme Court. And of course, the spokesperson for Willis declined to comment. Now, Fulton County grand jury in August that's just background. All right. So yeah. So if there's oral arguments, October 4th is when it'll be heard, and they have until mid-March to rule. And odds are they won't. If they rule early, it's probably not going to be till after the election. So we'll see all that going on. And then, just a quick update on with that. There's a motion to dismiss as impropriety granted. So this was filed by this was the motion. Or this was a statement. So on March 8th, 2024, this court granted appellate's decision to interlocutory appeal in the present manner, with the case now docketed the state of Georgia by and through Atlantic Judicial Circuit District Attorney Fannie T. Willis moves for an appeal to be dismissed as impropriety granted due to lack of sufficient evidence based upon the explicit factual findings of the trial court to support of the order at issue. Basically, Fannie Willis motion to dismiss this appeal, and it doesn't look like the court's got anything. So we'll see. Actually, something real quick. We're still waiting on a ruling from SCOTUS when it comes to Trump's immunity. I'm just going to see if there's any update on that. It's been a bit now. Let's see. I'm just looking up to see. Sorry, just looking. Yeah, so we heard arguments on this in April 25th. It's now almost been 2 months, right? April, May, June. Yeah, almost 2 months. Uh, let's see. So, I don't know. Let's see. Sorry. I'm just looking this up because I'm curious. Just seeing. Okay, so sometime this month we may hear um the opinion. Sometime this month. So we'll see. All right. Sorry. I got distracted looking that up. All right. Let's see. So we're going to go over this news report and then we're going to actually watch all this that happened. Yeah, a lot of clips when it comes to this thing. So, yeah. All right. A star witness is jailed for refusing to testify. A change of heart after the weekend spent behind bars, and then a lead attorney taken into custody for implying that an improper secret meeting led to the witnesses about face. Uh, all right. Welcome to another week in the gang and racketeering trial of chart-topping rapper Young Thug. A courtroom epic in Atlanta that continues to surprise as it approaches 18 months since jury selection began. Jesus Christ. Oh my God. This trial has been going on for 18 months. That's ridiculous. On Monday, Judge Earl Glanville took the extraordinary steps of holding Brian Steele, the rapper's primary lawyer, in contempt for refusing to disclose who told him about a closed door meeting between the judge, prosecutors, the uncooperative witness, and his lawyer. Mr. Steele had argued in court that the conversation was unconstitutional and the defense should have been present. Yeah, they probably should have, or at least notified. But in a heated exchange, Judge Glanville took issue instead of how Mr. Steele had learned of the meeting and sentenced the jail to a maximum of 20 days in jail for failing to reveal his sources. Listen, if you don't tell me how you got this information, then you and I are going to have problems, the judge said in court, to which Mr. Steele responded, I have problems right now. Judge Glanville, who has overseen the case since Young Thug, whose real name is Jeffrey Williams, was indicted along 27 others in May 2022, appeared increasingly frustrated when he continued, did you get that information supposedly from my chambers? Did someone they tell you? Mr. Steele snapped back, "You should have told me." In the courtroom, fireworks threatened to derail the lengthy and complex case that has been plagued with by delays, disruptions, including the stabbing of one defendant in jail, uncooperative witnesses, extra legal distractions, and fit of tensions from all sides. It's a circus straight out of Law and Order, said Anthony Michael Crease, a constitutional and civil rights lawyer professor at Georgia State University, who has observed the trial. So often I have to disabuse people of the notion that court is like those shows, but yesterday's drama just overshadowed everything. And that's really not helpful to the process. In addition to an appeal of the contempt order, which could take months to be resolved, Judge Glanville may have also opened himself up to motions to recuse themselves from both the contempt issue and the broader case. Yeah, I mean, seriously, if you're having a meeting with an uncooperative witness and the prosecutors and only his attorney and not the defense attorney, seems kind of bad. And then when the attorney asks about it and talks about it, and you're like, "Well, how'd you know about it?" I don't know. Well, look, why didn't you tell me? And then you hold him in contempt just because he's like, "I'm not going to tell you how I know about this." Seems a little biased there. Also, it could even open themselves up to a mistrial. The meeting between the judge, prosecutor, and the witness could also be grounds for an appeal by Mr. Williams or his co-defendants should they be convicted. I think honestly, there's more of a possibility of a mistrial. In emergency situations, a judge may meet with one side or the other, known as ex parte, although a judge is typically required to tell the other side that the meeting took place as soon as possible, which Mr. Steele, maintaining Judge Glanville, did not do. That's the kind of thing a defendant can argue deprived them of a fair trial. Lester Tate, a trial lawyer and former president of the State Bar of Georgia, prosecutors from the office of Fannie T. Willis, a Fulton County DA, says that Mr. Williams led YSL, or Young Slime Life, as a subset of the National Bloods gang, and that he oversaw the criminal conspiracy to commit murder, attempted murder, armed robbery, witness intimidation, and drug dealing. The indictment relies on the same Georgia criminal racketeering law, or RICO, that Ms. Willis used to indict former President Donald Trump and others in what prosecutors call a conspiracy to overturn the 2020 election. The latest rounds of issues in Mr. Williams' trial began on Friday, when a key prosecution witness, Kenneth Copeland, refused to testify after being sworn in, invoking his Fifth Amendment rights to protect himself against self-incrimination, despite having already been granted immunity from his testimony. Asking how old he was before ending his testimony, Mr. Copeland replied, "I'm grown." Mr. Copeland, known as Little Woody, was named in an indictment against a YSL associate, but was not charged in the case. An interrogation video showed Mr. Copeland discussing the activities of YSL was previously leaked online, leading to scrutiny regarding his so-called snitching, raising concerns about witness intimidation against him. After Mr. Copeland was held in court in contempt and spent the weekend in jail, he returned to court on Monday and agreed to testify, although he once again proved uncooperative. When prompted by prosecutor to identify a defendant, Mr. Copeland stalled and said he had visual problems. He responded to other basic questions with similar stonewall. Following a lunch break, Mr. Steele raised his concern about how Mr. Copeland had been compelled to testify, calling it potential coercion and witness intimidation by the judge and prosecution. In Judge Galvin's order of contempt and incarceration, wrote, in addition to the court's serious concern with how this information was improperly disclosed to the defense counsel, Mr. Steele made several claims regarding the sum and substance of the communication that the court found troubling. Well, then you probably shouldn't have been hiding this shit. On Tuesday, Judge Glanville scheduled a hearing on June 25th, in which he said those who were present for the private conversation, including Mr. Copeland and his lawyer, Kayla Bumpus, will be made to explain why they too should not be held in contempt for disclosing information to Mr. Steele in defense. After the contempt order, Colette Rensking Steele, a lawyer for Mr. Steele, who is also his wife and legal partner, immediately filed a notice of appeal, as well as a motion to purge the ruling. It certainly cannot be law that every time a judge asks a question, the failure to answer lands you in jail, Ms. Steele wrote in her filing. Representatives for Mr. Steele declined to comment further. This could be a huge turning point in the trial, Mr. Caress says. It's been a complete zoo sometimes, and you could say, well, that's not great, but the case moves along. I'm less confident about that now. After Mr. Steele's motion for a mistrial was denied on Monday, he was ordered to remove his tie and taken immediately into custody, although he later allowed to return to court and observe as the trial continued with Mr. Copeland testimony. On Tuesday, Mr. Copeland continued to testify with Mr. Steele present. Mr. Steele later requested that he be allowed to serve his jail time, which the judge ordered to be every weekend for the next 10 weekends, alongside Mr. Williams, so they could continue to work on the case. Sir, if that comes to pass, you have my support, Judge Glanville said. As a show of support for Mr. Steele, on Monday, some 24 other defense lawyers turned up at the court, led by Ashley Merchant, the lawyer in the Trump election case, who filed court documents accusing Ms. Willis of engaging in clandestine relationship with Nation Jade Wade, the special prosecutor she hired in 2021 to help with the case against Mr. Trump and his allies. Mr. Tate, the former president of the Georgia Bar Association, said it was extremely extraordinary for Mr. Steele to have been held in criminal contempt. It's just not okay for a judge to jail a lawyer for doing his job, Mr. Tate said. It's particularly not okay when the legal rationale behind that appears to be a pretty tangled web. Already the longest criminal trial in state history, jury selection began on January 4th, 2023, and opening arguments started more than 10 months later. The case was on pace to continue into 2027 without adjustment. A defense lawyer argued in a motion in April. Judge Glanville pushed prosecutors to narrow the list of 400 potential witnesses to more than 200. Less than half of those remaining have been called to testify. I understand the frustration of this case for Judge Glanville, Mr. Tate said. No judge and no lawyer tries a case for over a year and doesn't make errors. You're not entitled to a perfect trial, but this one has a certain circus-like atmosphere and a string of bizarre happenings. This may be the straw that broke the camel's back. Oh, that's fucking hilarious. All right, so now we're going to check out the actual court, the video. I got like 3, I think it is. So here's the first one.
Can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you a question. How did you find out about it?
I'm going to answer you the question.
Okay.
Scuttle, if you look at SCUDDER versus state, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me and you and Mr. Adams meet with me and others have met with me. It's those were ex parte for a lot of different other reasons, but I will certainly note that for purposes of the record.
Well, I'm going forward. What I was told was that Mr. Copeland said,
and you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to
No. I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have I have problems right now.
Okay, I know. Look, I don't want to know about your problems, okay, at this point in time. All I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversations with the party. I mean,
come on, Judge, it's obvious. He's white. He knows everything. he's got his white brothers going on and telling him all his juicy secrets.
party,
yes.
a witness who was sworn in Friday. The court's telling, this is what I was told. If this is not true, not true. This court
Mr. Steele,
handed
ask
Mr.
me.
Copeland.
Tell me how you
perjury.
got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it
or
proprietary?
Information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness?
You'll have a choice to make. All right. Take Mr. Steele into custody, please.
Oh, they're having a strip show.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of
Okay. All right.
Now, in case anyone wants to know why he had to remove his tie, it's so he doesn't commit suicide in jail. It's like a suicide, concern.
Right.
And also, if he's in jail with everyone else, they're not going to be able to murder him with the tie.
May I say one thing, Your Honor?
Yes, sir. You certainly may.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir.
Honestly, I don't see how this doesn't end up in a mistrial, because this is wild. I mean, it is Georgia. It's apparently very corrupt, apparently, with all the other bullshit that's been going on. But yeah.
We're going to be in recess for the next 5 minutes.
All right. So there's that one. I got something else that's coming up, but we're going to finish with these this interesting shit here. But I got something else in regards to Nathan Wade and Fani Willis. Now, real quick, the Georgia Supreme Court has ruled against Fani Willis and the corrupt judge in Young Thug trial, where attorney Brian Steele discovered a plot by Willis and the judge to intimidate witnesses. Now, to be fair, I think technically, Willis isn't really involved. She's just the DA. So she's involved in the sense that she oversees all cases, but she's not actively involved like she is with the Trump case. Okay. It's prosecutors under her purview is who's involved in this, I believe. So let's see. So yeah. The Steele was held in contempt of court by the judge after revealing he knew that we already saw that. So this was the appeal, I guess, a criminal emergency motion. Let's see. Super. I guess that means. Okay, so it's suspending a particular proceedings. Let's see. So there's that. Now we got let's see. So this is what we just watched, probably just a shorter version. Now, this is another one where okay. Sorry, trying to figure out. So this is at the Trump lawyer.
And Judge, I'm not the only one here. There's.
Oops.
I'm not the only one here. There's quite a few other lawyers that want to be present in the court. There's about 20, 25.
The challenge is I've had space allocations, as I told you. So
And Judge.
Okay, so that's her. That's just the beginning for some reason. But here we got. Wait, what the? Hold on. There we go. Here's the longer one.
Orderly process of the administration of justice, the preservation of order and decorum of the court is exempt from due process requirements of notice and hearing. That's even Moody, goes back to 1974. So I believe that Mr. Steele's, he can file whatever motions, but his particular actions in this case, I just want to know who told him this. That's all. I'm not asking him to release or
Fuck off,
otherwise
dude, Judge.
tell any conversations, but I just want him to tell me that.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean that you have the power to hold him in contempt.
So you can come into court, Mr. Merton, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained.
No wonder this is. Oh god, this is great. This is great. I just want to. Yeah. So let's see. I'm just looking. So yesterday, the ruling was made on Steele's emergency motion. I think the trial is still going forward. So he's let's see. Yeah, so I think the Young Thug trial is still going forth. It's just this particular thing that is not is being appealed.
Not from your client, but in representation of your client. He has the ability to protect that information. But we don't even need to get there because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith that he believed there were ex parte communications. You are a witness to that because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you aren't part of them by nature.
Okay. Well,
you have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also.
But you got the information. But here's the thing: you got the information allegedly from an improper methodology. I'm not saying that he eavesdropped. Okay, I said that one of the things is it's either one of two ways. He either eavesdropped, which I don't believe he did at all. I don't believe that for a minute. But I do believe that somebody did tell him what was the sum and substance of the court's conversations, and that would not be permissible.
Judge, let's just back up for a second. He makes a motion because he has reason to believe that there were ex parte communications made. The court has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned it.
I think that he caused that particular circumstance. I think that he had a conversation with somebody and he got some information that he shouldn't have had to begin with. So, Ms. Merchant, I'm of the opinion I'm going to stand on my ruling at this point in time. I'm going to hold him in contempt. So at this point.
Yeah, that didn't last long, motherfucker.
In time, is there anything else you want to tell me?
Yes, Judge. There's quite a few other things. We would ask for you to be recused from this case because you are a witness necessarily. It cannot be an ex parte proceeding without you being a witness to this. So you are a witness to this proceeding. Therefore, yes, to the contempt. To the contempt. You are a witness to the contempt. So you have now, and if it's criminal, which is what you're saying it is, Mr. Steele is entitled to all the same due process rights that Mr. Williams and every other defendant in this courtroom is entitled to. He's entitled to those. One of those is to have a fair and neutral judge decide his case. One of those is to have a judge who is not also a witness in the proceeding deciding whether or not he's in contempt. This needs to be heard by a different judge. And he has the right to subpoena witnesses. He has the right to an attorney. He has the right to due process, notice, a show cause hearing, notice of the alleged violation, whatever rule it is that the court believes, and a hearing where he can call you as a witness. You can testify. You are necessarily a witness. You can't, for it to be ex parte, you have to be a witness. It can't be both ways.
I'll let an appellate court decide that. So, anything else?
No, we'll file a notice of appeal.
Okay.
And we need to have the order reduced in writing as well.
I'm going to do that right now. I will state for the record at this point in time that Mr. Steele has in fact, or has filed, and I will note this as part for the record in this case. He's filed a motion to set aside the contempt. He's filed a motion for a superseded bond, and he's filed a notice of appeal, all of which I will include as the next court's exhibit in order. But I'm reducing the contempt to writing. And I mentioned earlier, he can purge himself of the contempt just by telling me who it was, and he can do that this evening. He can do it right now. He can do it at any point in time. If not, I'll revisit the circumstance on Friday.
And Judge, we would ask that you grant the bond. At this point, criminal contempt, he's got to be sentenced.
Well, his contempt is, as long as he, when he tells me what the basis of the conversation was, who, I didn't ask what, but he tells me that, then I can certainly, he purges himself of the contempt.
Then that's civil, Judge.
That's civil contempt,
That's civil.
Judge, and that's respectfully, I would point you to In Re Hughes, which stands for the same point of law. Civil contempt impose punishment as a means of coercing future compliance with the prior order of the court. Here, the prior order of the court presumably is that you have directed Mr. Steele to answer the question, to disclose the information as to who is his source for knowledge of this ex parte meeting that occurred earlier today. Criminal contempt imposes unconditional punishment to punish the act which has occurred in the past and cannot be purged. It is not capable of being purged, in which case what Ms. Merchant said applies, which is that there is a 20-day maximum sentence and $1,000 fine. It is, for all intents and purposes, a misdemeanor offense, Judge. Which is why the enhanced due process protections apply to that. Now, Mr. Steele has indicated to us he does not believe that he can answer the question without violating his duty of loyalty and duty of confidentiality to his client. So he is being placed in a position where he's either going to jail or he's going to commit an offense that will put his license to practice law at risk. And that is an untenable position to be in. And Mr. Steele is a zealous advocate for his client, and he is simply trying to protect that duty of loyalty and duty of confidentiality, because if he answers your question, it is very reasonable to assume and likely that he will be facing a bar complaint that could result in a suspension or in the loss of his license. And so he's in a very, very difficult position where if we were able to have a full contested hearing with the benefit of witnesses and an impartial judge where you're a witness, then everybody could present their side of the story. And
I'm not doing that. The reason being is because that takes away the whole point of criminal contempt. And that is, you do something, the court tells you to do something, order of the court, and you don't follow it. I didn't ask him to do anything illegal, immoral, unethical. I just asked him to tell me. I know what the privilege is. The privilege is the conversation. I didn't ask him about that. I wanted to ask him about who, the person.
Yeah, but wouldn't you be able to then go to that person and threaten them with contempt or some sort of order to get them to tell you about the conversation? Because I could be wrong about this, but I think the attorney-client privilege probably only, I'm not wrong about this, but attorney-client privilege only applies to attorneys. So if, this judge went to, found out who who it is that told the lawyer about, whatever he told him about the conversation that the judge had with the witness. And then the judge could then go to that person and say, hey, I'm going to hold you in contempt. And, you're not going to have any, way to really protect yourself against that. And if you don't tell me the particulars of the conversation, I'm going to hold you in contempt. And you don't have the excuse of attorney-client privilege, so you're going to end up getting in trouble until you tell me. So that's probably the reason why he doesn't want to tell them who it is he had this conversation with, because then it's yeah. Anyways, but yeah, so you can't you're not gonna fucking walking all over my words. But yeah, he's not. He's basically guaranteed to be the judge finding out what the conversation was, and because the attorney-client privilege only helps his side. But the judge would easily just go to the guy who told him, or girl who told him, tell me, and then he would know the aspects of the conversation, which is why Steele isn't gonna tell him who told him.
Because okay, I'm sorry.
Sorry, Mr. Steele has indicated to us that he does not believe he can answer that question without also violating the privilege.
Okay.
And Judge, that's why we're trying to figure out if it's criminal versus civil. So the issue is you're picking and choosing. You're saying, well, you get the bad side of criminal and no bond, but I really am actually trying to punish you civilly, which is when you hold someone until they comply.
Okay, let me think about this a second, okay? I'm gonna
Just like, fuck, I'm fucking myself over here. He's like, shit. Now I gotta think this over. But yeah, again, Brian, Attorney Steele is, he's not going to jail this weekend. Appeals court that's like, hey, can't do this. We will see when that happens. Actually ends up happening. Who knows when it will? But yeah, so it's good for Steele. Good for him. All right, now real quick, this just showed up on my feed, so we'll check this out. So this is apparently Nathan Wade. Well, this is Nathan Wade talking to, what's this broad's name? Caitlin Collins, and he apparently walks out on this interview. So let's check it out.
Just to clarify, when did the romantic relationship between the two of you start?
Yeah, so we get into. There's been this effort to say that okay, these exact dates are at issue, and these exact dates are. I'm getting signaled here.
Yeah, take it. Want to go off mic for a second?
Yes.
Okay. Go off mic for a second.
keep rolling.
Keep rolling. Don't stop down.
Okay, so he got up mid-interview to consult with someone. Hey, make sure you say exactly the same thing you said when you swore under oath, or you can get in trouble.
Yeah, good.
Everything okay?
Just really pretty guys.
Yeah.
Just to revisit the question, it was to clarify when the romantic relationship started and when it ended.
Sure. So, I believe that the public has, through the testimony and other interviews, the public has a clear snapshot that this is clearly just a distraction. It is not a relevant issue in this case. And I think that we should be focusing on more of the facts and the indictment in the case.
Well, I ask because obviously it's still a pending matter. It's going to be before the Court of Appeals. And you talked about how proud you were of all the work that you did in this office. And I think the question that people have when they hear from the Court of Appeals, this isn't happening until next spring, is Did the relationship jeopardize that work that you did in this investigation?
And therein lies the issue. Why we wouldn't touch upon the work of the Court of Appeals or some higher court, because it's the pending issue before them. I think that we should allow them, take a step back and allow them to take the evidence that they have and do their work, make the decision.
Right. But you did testify to this, and you were asked about on the stand about when it started and when it ended. It just wasn't completely clear, because before it said before the indictment, which was August 15th here in Atlanta. And then later the answer was at the end of that year. And so I think that was the clarity that people were seeking of when it started and when it ended.
Sure. And there again, there's a question before the court. And that is the crux of the question. I don't choose to say or do anything that would jeopardize the case or the court's ruling. I prefer to allow them to make their decision based upon what they have. And
it's such an invasion.
Do you believe, as you reflect on this, that your relationship with the district attorney was a mistake?
Absolutely not. Absolutely not.
Considering you got kicked off the case and odds are she's going to get kicked off after the appeals, probably should be like, yeah, it was a mistake.
What I believe is this whole conversation is a distraction. That's all. It's a tool.
Oh, it's a distraction. Maybe you guys shouldn't have engaged in this before.
To stop the train, to slow down the inevitable, which is the trial of the defendants named in the election interference case.
Do you believe the trial ultimately happens?
Absolutely.
No.
Absolutely it happens.
Well, now, it probably will happen, but the DA is going to be removed for sure. Penny Willis is going to be removed for sure.
Mr. Wade, thank you for your time today.
Thank you for having me.
Thank you.
That was such a weird evasion. Like it doesn't, like anyone who watches this, it's just like, this is weird. This is weird. Okay, this is really weird that this person like this is just weird. Like that was just a weird evasion, and then he gets up mid conversation to consult with it and everything, and he comes back and just evades the goddamn question. It's like, oh, well, it's not that important. It's just a distraction. It's like, no, it's a kind of an important question. It's weird. Like it's just that was just weird. That was just weird. It's kind of funny as hell, but it's weird. All right, moving on. Let's check out a monster. Yeah. So, this woman, Bianca Ellis, is accused of murdering a 3-year-old boy and mocked the court as she was charged. We'll watch the video of this because I got video of it. All right, I got video of it. It's fucking weird as hell. All right, so a mother and son were attacked for no apparent reason, according to local police. Now, here is my assumption for the reason. All right, call me racist. This is my assumption because I got no other information. So this is my assumption. All right, they were white, she's black. That's my assumption, honestly. That's all I got. As far as I know, it's the only reason I can see. And it's based off of just the lack of reason, like any like actual reason for it. And also her behavior when the charges are being read. Okay. So one of the most sickening stories to emerge in 2024 is that a 32-year-old woman who stabbed a 3-year-old toddler to death in Ohio, but who is the offender, and she openly mocked the courtroom when she was charged? What the fuck? All right, when Julian Wood and his mother headed to Northern Olmsted Eagle store on June 3rd, they did not think it was going to be the last time they go about their daily routine together. But Bionica Ellis, had sinister plans as she robbed the kid of the rest of his life. Ellis, who was 32 and from Cleveland, followed mother and child from the store to the parking lot before charging them with a knife, stabbing the defenseless toddler twice, injuring his mother too, before walking away. All this took place in the span of 5 seconds. 5 seconds to destroy Margaret Wood's life. Although Ellis didn't seem to care too much based on her courtroom appearance, that saw her smiling and giggling as she was charged as she had charges reading or read to her. Let's see. Ellis has been charged with aggravated murder, attempted murder, felonious assault, endangered child, tampering with evidence, and misdemeanor theft, something which she pleads not guilty to, whilst her defense lawyer claimed she has mental health issues. Bail is set at $5 million. Shit. That was. $5 million for a bail. So let's see. Normally, if you post like there's no way she's getting out of jail for this. Let's see. So it's like what, 10%? So what, 500K? Yeah. So 500K. So she can post 500K to a bonding. See, they might lend 5 million, but they probably won't. After appearing to be unable to understand the indictment against her at whatever county, I'm not even going to attempt to say that, the Court of Common Pleas Court, Judge Nancy Margaret Russo eventually requested an attorney to explain to Ellis as she shook her head as though she didn't understand and didn't answer any questions. The lack of remorse and accountability clearly hurt the family, who lost their new life in a random attack that will leave them scarred forever. As Jared Wood, Julian's father, appealed for her to remain in custody. There's nothing that could ever replace my son, Jared Wood emotionally said to the court, or anything my wife and I and our other kids are going through. It's horrendous. Just do whatever you can to keep this monster behind bars. All right. And then, so apparently, let's see. So the range suspect who stabbed toddler to death outside supermarket was freed from jail just days earlier as judge defense decision. So a suspected deranged killer charged with stabbing a 3-year-old, whatever. I've already read it. All right, but it has since emerged that Ellis has another run-in with cops just days earlier after she was taken into custody on May 29th for a probation violation tied to a petty theft arrest. Records obtained by Fox 8 shows. During her arraignment for the probation violation arrest, a Rocky River Municipal Court magistrate ordered Ellis, who's accused of stealing $69 worth of merch from Walmart, to undergo a psych check after it became unclear if she was paying attention or fall asleep during the proceedings. May 29th. Ellis then ended up back on the streets on May 31st after a different magistrate, Judge Brian Hagen, ordered she be released from custody. This wasn't any red flag shooting up that pole, Hagen said as he defended her decision to cut her loose. There's no any indication here, no sign of mental distress, no sign of previous violent acts. Judge added the mental health team that carried out the evaluation for the court did not have anyone available, which meant Ellis, who has no known violent criminal history, would have been kept locked up for days on a minor case. So... Like, I understand, like releasing her. I understand that. Like, I get that. But, if they didn't have anyone available, but one judge was saying, hey, it's a mental case. Like, is she mentally there? It probably would have been more prudent to verify that she was mentally there, as she appears. It was unclear if she was paying attention or fall asleep during proceedings. And then in the prior one, she kept shaking her head, acting like she didn't understand what was going on. So it could have been valuable to kept her there just so she could have a mental evaluation. So I understand, like, now I understand, like, I think he should have kept her for the just to get the mental evaluation. But his reasonings for releasing her, besides that, it's sound. She has no prior violent history of it at all. The mental evaluation was requested just due to the fact that she was looking like she was falling asleep or not paying attention. So I guess I can understand the judge. Like, look, this doesn't seem like something that needs to be a mental evaluation, because all it wasn't like she couldn't understand what was going on or wasn't acting strange. She just wasn't paying attention or was falling asleep. This was a minor $69 charge of petty theft. So I can understand the judge's reasoning. I'm changing my decision. I understand the judge's reasoning, and I think it's a fair reasoning. It'd be one thing if she's had a history of violence and then there was a mental health evaluation and they released her, but there was apparently no indication of any violence in her past. So I get the judge's reasoning. Now let's look at this monster, and she seems to enjoy the limelight. And she ain't getting out for now at all now. $5 million. She's after coming with $500K. Come on. All right. So let's listen to this. This is her, obviously, and this is the kid that she stabbed for whatever reason.
Code section 2903.11A1
Going live,
and or endangering children in violation of Ohio Revised Code section 2919.22B2. Count 4 alleges that on or about June 3rd, 2024, the defendant did knowingly cause serious physical harm to JW on.
The funny thing is, all this can be used against her too. Like when she goes to court, this can be used against her. Like they can be like, this is a person not showing any remorse. Look at her.
Date of birth 10/29/2020. Count 5 alleges that on or about June 3rd, 2024, the defendant did torture or cruelly abuse JW, date of birth 10/29/2020, a child under 18 years of age, and furthermore, the violation resulted in serious physical harm to JW, date of birth 10/29/2020. Count 6 alleges that on or about June 3rd, 2024, the defendant did attempt to purposely cause the death of Margot Wood. Count 7 alleges that on or about June 3rd, 2024, the defendant did attempt to cause the death of Margot Wood as a proximate result of the offender committing or attempting to commit an offense of violence. It is a felony of the first or second degree, to wit, felonious assault, Ohio Revised Code section 2901.11A1. Count 8 alleges that on or about June 3rd, 2024, the defendant did knowingly cause serious physical harm to Margot Wood. Count 9 alleges that on or about June 3rd, 2024, the defendant did, knowing that an official proceeding or investigation was in progress or was about to be or likely to be instituted, alter, destroy, conceal, or remove any record, document, or thing with the purpose to impair its value or availability as evidence in such proceeding or investigation. Count 10 alleges that on or about June 3rd, 2024, the defendant did with purpose to deprive the owner, Volunteers of America store, of property or services, to wit, knives, knowingly obtain or exert control over either the property or services without the consent of the owner or the person authorized to give consent. I have now read the indictment to you. Do you wish to enter a plea of not guilty?
Sí.
Pardon me?
Sí.
What's same mean? Yes or no?
Yes.
Okay. I understand the victims are represented and they want to make a comment before I set bond. Is that true?
Yes, Your Honor.
Okay.
Okay, this is the father.
Good morning, sir. Could you start with your name?
My name is Jared Wood, father of deceased, husband of Margot. Your Honor, that day, 1 week ago, she took everything from us. There's nothing that could ever replace my son or anything that my wife and I, even our other kids, are going through. It's horrendous. I really wish no bail period, or extend it to the max limit possible by that you can.
Well, you got what he wanted, $5 million.
Just do whatever you can to keep this monster behind bars.
Thank you, sir. Is there anything else you would like to say?
That'll be it. Thank you, Your Honor.
Thank you.
Get her. Get her, dude. Get her. Get her. Go on, get her. I'm sorry, I'm rooting for her to like break free and beat the shit out of this broad. Fuck this shit.
Is there anything else before I pronounce bond?
Your Honor, we would just ask that you consider assigning the public defender's office, recognizing this is not our number. We did represent her at the first appearance unit. I did meet with her on Friday. We have had contact with her family and begun working on the case. Thank you, Your Honor.
When the original bond was set out of Muni Court, the bond was set at $1 million, and it was before the passing of one of the alleged victims. I do not believe that bond is appropriate given the change in circumstances and the allegations that are contained in this indictment. Bond is set at $5 million, cash, surety, or property. GPS, no contact with any surviving victim or victim's family, DNA order. Judges John Russo, pretrial is June 17th at 9 a.m. I'll assign counsel.
Thank you, Your Honor.
Thank you, Your Honor.
Code section 2.
Okay, so hearing's June 17th. Maybe I'll check that out. When is June 17th? Monday? Might check that out. I'll give it a look. Well, probably June 18th. Yeah, so that's a garbage human being right there. I don't have to do that because it was already in that thing. Yeah, you can see her. She's just smiling, laughing. Go when asking a question, answering C like she's fucking Spanish. What the fuck is this shit? Yeah, it's just an evil individual. I'm sure she's gonna go to jail. She pleads not guilty. Come on, bro. Come on. So hopefully this monster gets put away in jail. We will check that out and see. But yeah. All right. So last but certainly not least, this comes from Spokane, Washington. This is the spokesman review. An East Valley teen is the first Washington transgender athlete to win a state high school track championship, but controversy followed. Now, obviously, this is a dude thinking he's a chick. All right, there we go. Let's see. Veronica Garcia did not hear the boos when the race started last weekend. When he took the lead, I'm not doing this. It's not she, it's a he. When he took the lead in the state's 2A girls 400-meter run at track and field in Tacoma, they grew in volumes and became Tacoma. They grew in volume and became unmistakable as he reached the finish line. That's going to be really difficult. I'm going to slip up to become the first transgender high school athlete to place first in state. Such victories are typically a time of celebration, but the East Valley High School junior wins has sparked controversy. People criticized Garcia all season for participating on the girls' track team, yet the jeers at the Saturday's meet was a bit more severe. He said. Garcia cheered and clapped for his competitors as they received their medals. When the announcer called her to the podium, the crowd fell silent, and other high school runners at the podium did not acknowledge him as they stood up with hands clasped behind their back. Good job. After he accepted his gold medal, a voice from the crowd could be heard yelling, "He's not a girl." Garcia expected the chilling reaction from the crowd, though he was somewhat hurt. His peers did not offer congratulations because they're not your peers, dude. You're a guy. You're physically superior than most of those girls. So yeah, they're not gonna. Yeah, good on them. Good on them. It's good to see like women finally fighting back against this shit because the people who've been rallying against this are just tired of it because if the people in it aren't going to do shit, then there's no point of us doing anything about it. And I've come to the thing of if women want to let this shit happen, then I'm not going to fight for them against them for their benefit. If they want them out, they're gonna have. If they want men out of female sports, they got to get doing themselves at this point. I'm tired of trying to open against that. I'm just letting the women take care of this. All right. They're equal now, right? All right. Let's see. I guess maybe I expected sportsmanship because I was cheering the rest of them on when they were called. So I expected to get that reciprocated, he said. But I didn't get that. That's because it's very unsportsmanship to have a guy racing against girls. While the national debate continues to rage regarding the fairness of transgender participation in girls' athletic competitions, Garcia said what's lost is the subject of these controversies are often teenagers trying to have fun in a sport they love. I'm just a teenager. I wish people would remember that, Garcia said. Yeah, sure. Okay. State meet results. The 16-year-old Garcia pulled away from his opponents with a time of 55.75 seconds in the final, a full second ahead of the second place finisher at the state meet at Mount Tahoma High School last week. His win helped the East Valley Knights win the 2A title. Garcia did not set a state meet record in the 400. This is held by Jalen Merriweather, who in 2017 ran the 400 in 53.83 seconds. Now, if this guy was competing with the males, he wouldn't be making first. That's the thing. Guaranteed he wouldn't be making first. He's probably like a mid-tier runner. Records were set at the meet by East Valley senior Logan Osfeth, who swept the long whatever. East Valley Athletics Director Eric Vermarni said he did not want concerns about Garcia's participation to overshadow his and the team's accomplishment. Veronica contributed, no doubt, but it was a group of girls and a guy that did something as a team. They are elated. He said, noting that this is the first state championship for the East Valley girls track team since he was hired at the school 7 years ago. For 18 years, the Washington Intersocial Elastic Activity Association has had a policy allowing students to compete in the division of the gender they most consistently expressed. Let's see. All students have the opportunity to participate in WIAA athletics or activities in a manner that is consistent with their gender identity. Washington is one of 6. I don't believe that for 18 years that's happened because I've never heard of this happening until recently. So I don't believe that 18 years crap. Washington is one of the 16 states with policies that allow for full participation of trans, non-binary, and other gender diverse students in schools. Other states may have more restrictive rulings to prevent transgender students athletics from competing in their preferred category, or more restrictive requirements about their participation. East Valley High School sits less than 8 miles from the border with Idaho, where state lawmakers have been attempting to restrict transgender students from participating in girls and women's sports. In 2020, Idaho became the first state to ban transgender participation in school sports, dubbing the Fairness in Women's Sports Act. Now, to be fair, they're not banning transgenders from participating in school sports. They're banning them from participating in women's sports. So you could just participate in men's sports. Let's see. Okay, so yeah, it explains that here. The lawsuit was filed claiming the bill is discriminatory. The Idaho law has not been allowed to be enforced since its passage and is currently under consideration by the 9th U.S. Circuit Court of Appeals. Unlike some states, Washington does not require transgender students athletes to undergo hormone replacement therapy or suppression of hormone naturally produced by their bodies. Transgender athletes in Washington also are not required to disclose their medical information to play high school sports. Garcia declined to disclose whether he has been prescribed hormonal replacement therapy, medicine, or puberty blockers. Efforts this week to interview Garcia's mother, Tracy Brown, have not been successful. However, late last year, Brown said she supports Garcia 100%. I'm so proud of him, she said at the time. When determining Garcia's eligibility to participate on the girls' track team this year, Vermari said he is following federal law, state law, and WIAA rules. People feel like we've done something that we shouldn't have. We shouldn't have done, he said, but we're doing everything that the way it is laid out to us. Okay, you still shouldn't have done it. Let's see, WIAA spokesperson Sean Bestit. I'm just skipping this because it's not important. Acknowledge the organization received multiple complaints about Garcia in the weeks since his victory. In defending their policy, Besset cited state law prohibiting discrimination and federal Title IX protection, both of which include transgender identity as a protected class. Let's see. The WIAA consider numerous personal, political, and religious belief communities that joined the association, according to a statement provided by Besset. Many of these beliefs do not align, resulting in conflict among the diverse groups that a association serves. For this reason, the WIAA executive board has been advised to follow the state and federal law. Beth Darsangi, Republican running for a state house seat from the Seattle area, who has protested multiple sporting events with transgender athletes, attend the track meet to support women's and girls' sex-based rights. She wants the WIAA to change its policy. Just seems unfair, she says, of Garcia's eligibility to participate in the competition. Sports are based on physical competition. It's not based on identity. Yeah. So that's why we should keep sports based on physical distinctions between male and female. Signs in hand, Darsangi and several other protesters stood outside the fence protesting Garcia's participation in the state track meet. She said the competitors who lost to Garcia were being bullied by their school districts and the WIAA by allowing Garcia to compete. They were probably furious and hurt, feeling overwhelmed by the fact that they have no voice in this, she said of the high school athletes. Darsangia said she hopes Garcia receives treatment for gender dysphoria, which she called a real condition, but by participating in girls' sports, she says Garcia was doing something deserving of criticism. Garcia was belittling and stealing from the other girls. Darsangia said, I don't wish anything mean, but disagreeing with someone is not mean. Protesting something in civil language is not mean, she said. Following Garcia's victory, several high-profile critics of transgender athletes rebuked the East Valley student. This include Riley Gaines, who spoke out against transgender people's inclusion. Let's say transgender women. Let's be honest. There's not a lot of transgender men going to men's sports and dominating. Let's just be accurate here. Come on. Inclusion in sports after tying for 5th place with a transgender athlete in a collegiate swimming competition. Would you look at that? The thing that never happened happened again. Gaines posted on X. She called Garcia a boy who dominated the event. Yeah, it was like a full minute or a full second or something like that he was ahead. Garcia received support from Spokane's Odessa Youth Movement, which provides support and resources to transgender youth in Eastern Washington. Executive Director Ian Sullivan congratulated Garcia on behalf of the Odyssey Youth Movement and said transgender, non-binary, and gender diverse youth should have the same rights and opportunities as any other students. Sure, they just have to compete in the same category as they were born as. Schools, activities, and extracurriculars are designed for growth and development of all students, and we also, as a community, should be working together to support and uplift every student in Washington State. Sullivan said in a statement. No, let's be honest. They're not just designed for that. They're also designed to provide opportunities for individuals that are, wouldn't be able to otherwise to gain, scholarships and whatnot and achievements and stuff that would look good on college applications. That's also why they're designed for. When you let a bunch of dudes come in and take all those scholarships away, what is it left for the women? I don't care anymore at this point. At this point, women, you're going to have to get up and do the work. You guys voted for this shit. You guys can fucking fight for it back. I'm not advocating for this shit. I will speak out about it, but I'm not advocating for it anymore. It's up to women now. Oh my God. Negative attention and controversy could have a severely negative impact on Garcia, said Dr. Kellen Bryan, an executive director of Whitman Walker, a national organization that provides health care to the LGBTQ community. It's horrendous. There's already a mental health crisis among young people in this country, trans or not, and to be attacked for wanting the same thing that every other teacher wants, which is to fit in, to belong, to participate, to be on a team, to play. That's incredibly damaging and it's incredibly cruel. Yeah, not giving a fuck about the women on the team, the girls on the team who have to are trying to work with their limitations because they can't compete against the boys, so they have a whole separate team. Fuck them. Let's care about this one individual person that, instead of actually getting some therapy and some psychiatry and mental health to stop him from thinking, oh, I'm a chick now, and instead having him talk to a therapist, go through and instead of enabling gender dysphoria, cure it by saying, hey, you're a dude, you need to accept that you're a dude and be happy that you're a dude. Okay, I know being a dude sucks and everything, but you need to accept that you are a dude and you have to be a dude. Sorry. Let's see. Since beginning his gender transition last year, Garcia said he received a taste of how hard we as a species can be for absolutely no reason other than being a little different. No. See, let's be honest. No one would give two fucks, okay? If you were just a transgender person, you were just living your life and doing shit. No one really would give two shits. Let's be honest. None of us would really care. If you're just transgender, you're just going your life about it and everything, no one really cares. It's when you start invading women's spaces, okay, that people start to care, all right? If you're transgender and you still use the male bathroom because you're a dude, but you just like to dress as a woman, thinking you're a woman, no one gives two shits, all right? If you wanted to compete in sports, but you competed in the male sports, but identified as a chick, no one really give two shits. They're like, all right, whatever. But when you start invading women's spaces, that's why there's controversy. Okay, it's not about being different. It's the fact that you're invading these spaces that have to happen, or that have to be there because women aren't able to compete physically against men. Okay, and you're born a dude. And you've grown up as a dude. You're, what is it, junior? So you've gone through puberty as a dude. So you're a lot, you're a lot physically stronger than most of the women. Like if you competed in a dude level, you probably wouldn't have placed. That's probably where it was. She said she's been he said has been bullied on and off the track, and has been subject to what he calls discriminatory comments invalidating his identity as a transgender girl. Most of it comes from adults, not her classmates and teammates. His track team has become like a family to Garcia, and their support has ushered him through dark days when he feels like an outcast. I can be myself and something in a way that I've never been really able to do. I kind of feel like I'm living my authentic self, Garcia said in the past year. Garcia said Vermari has been his biggest supporter since coming out. Regardless of the situation, this is still a kid. Vermari said of the backlash, it's a polarizing situation, but we need to support kids. That's what we do in education. Yeah, you support them by not feeding their delusion, but by, hey, come back to reality. This is how it actually is, okay? When you feed into delusion, you're just hurting them far more than you'll ever help them. It is in part of such a support that Garcia said he has come to love competing in track. He doesn't race for the medals. He races because he enjoys it. Yeah, sure. Okay. Garcia admitted that there are not easy answers to transgender inclusion in sports. Actually, there are. There's two very easy answers. Either or, I don't care. One, completely separate division. All transgenders get to compete in the same division. Okay. There's a separate division. That's option one, answer one, or answer two, one or two. You just got whatever you were biologically born as. that's the sport you compete in. Okay? Simple as that. That's the division you compete in. If you're biologically born as a boy, doesn't matter when you transitioned, you compete as in the boy sports. If you biologically was born as a woman, you compete in the women's sports. So it's very easy answers. Either A, you participate in the sport that you were born in, so male, female, whatever. Or B, we just have a separate division for transgenders. Okay, separate division, which ironically, honestly, would just end up being a second male division without actually being called a male division. That's all it ended up being. But he wishes those who think he should not be able to compete would take their complaints to those who make policy decisions rather than yelling at him. Well, you're the one making the decision to do that, so it's fair to yell at you when you know that this is wrong. You shouldn't be competing with females when you're a dude. But I agree. The complaints should be taken on to those who make the policies, but you're the dude who's doing it too. Okay. I'm just a teenager. It's one thing if you want to advocate for whatever, but your message becomes deflated when you start insulting. He said, as soon as you start harassing transgender people, transgender women, let's be honest, I think your message starts to fall apart. At least give us respect. Why? Because I think the best thing anyone can do, even if you don't understand why we're transgender, the very least is to be nice to us. Kindness goes a long way. Why? Okay? Why? Why should we give you respect? You are competing in a female sports, knowing you were born a male, knowing that you could easily defeat most of the females, which clearly you have done. So why should we give you respect when you're not doing something respectable? You're competing against individuals that are inferior to you physically, but then you demand respect. No, when you do respectable things, you get respect. When you don't do respectable things, you don't get respect. Sorry, that's how it works. So fuck off. All right. So that's all we got today. We talked about a lot, honestly. No, it's not Elijah Marie. It's not determined by gender located in the soul, not it's what you're biologically born as. Soul. What kind of crap is that? My soul. Stop that bullshit. No, you're born biologically a male as if you're born a male. Biologically, you're a male. That's why you shouldn't be in female sports. It's the reason why we have a separate division altogether. Anyways, hope you guys enjoyed the video. Make sure you like and subscribe. And yeah, check me out. And yeah, be back here. I'm not lying. You're just dumb. I agree, man. That transition to a women's sport should not be participating in sport. And women's sports isn't fair, but you are lying. No, they're not born that way. They're psychologically unwell. That's why it was gender dysphoria and not anything else. They're psychologically unwell. And if you would talk to them and get them help. And Donald Trump is a man of sin. The Bible promises to banish. So you're a Bible thumper, but you also think transgenders are born that way. Okay. All right. Probably Protestant. All right. I hope you guys enjoy the video. Elijah, have fun. Hope you have a good day. Peace out. And I will see you later. Peace.